Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle.
We are live. It's the community and the law brought to you by BWF Solicitors. This afternoon, very nice Saturday afternoon, we're asking you to join us and help us or even join in the discussion on how to make a successful spousal application whilst in the UK. Our resource person and guest will be Lawyer Charles Asma from BWF Solicitors. It's the 24th of May, 2025. It's a community in the law brought to you live on BW TV. Let's get into it together. Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Show starts at 6 p.m. with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP, includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexachampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing, and hosted by Alex Achampon. it's guaranteed to be awesome.
It's always a pleasure to come your way every Saturday afternoon like this when we join the lawyers from BWF Solicitors to have a discussion on what's bothering us, especially when it comes to immigration matters here in the UK. This is BWTV, and we're bringing you the community and the law. My name is Uriku Frimpona, and thank you very much for sticking around all this while and also deciding to join us again this afternoon for another edition of the community and the law. This afternoon, we're looking at a very interesting topic, and we're asking how to make a successful spousal application whilst in the UK. We're posing this question to Lawyer Charles Asma, who is going to be a resource person and guest this afternoon. And remember, we're doing this courtesy BWF Solicitors. We're live on BWTV at BWTV on Facebook, at BWTV on YouTube, and also at BWF Solicitors, both Facebook and YouTube. We will have the segment where we'll ask you a quiz question, of course, and also to find out how you have learned from the nugget we'll put out, and also have Lawyer Asma to explain to us. Then again, you will have the opportunity to send in your questions and comments, one on the topic that we'll be discussing, or any other thing that's bothering your mind this afternoon. And Lawyer Charles Asma is ready to help us with that. Remember, we're doing this courtesy BWF Solicitors. I've said it over and I want to say it again. You can call them on 0208 493 7340, 0208 493 7340. Or if you're in Ghana, the number is 055 589 5959, 055 589 5959. In emergency situations and at any time, you can send a text, WhatsApp, or call 0044 7712 761884. You can find all the numbers at the bottom of the screen at the moment. Now, let me ask you, somebody does something for you and you're so excited about that. What do? You say thank you to the person. That's why we have people who have sent us the appreciation. We'll be going back to that. But those of you who have joined us and are live with us online, either at Facebook or YouTube, I want to acknowledge and say thank you, welcome. But do one thing for me when you come in here. It's like you've come home from outside. What do? You wash your hands, remove your shoes, and of course, settle down and say hello to everybody in the house who's been in there before you. So let's do it right now. Hello to everybody that's been here. Tilly Duma, I know you are always happy to start with us. Nana Ya says, happy Saturday. Thank you very much, Nana. Tilly Duma, as I mentioned, you are saying hello to the lovely family we have. We're all here, we're waiting. You're calling out? Yes, Nana Jimai and all the other people come. Margaret Dumens, you're being called. Nanette Yahini, Tilly is calling you. Then we have Fred Amoa. Freddie, are you here? Yes, I believe you are, and you will kindly comment and like the page. So thank you very much to all of you. Ade Terrible is around. 80, I'll call you. Good afternoon. Please share when you join, he says, and I want to reiterate that. Please share when you join. All the other people that will come in will find time to acknowledge, but for this, we want to say thank you very much. And let me again say that we have gone into the stables of BWF Solicitors. We brought out Lawyer Charles Asma, who's going to be a resource person and guest. Let's introduce him and welcome him to the show. Lawyer Asma, good afternoon.
Good afternoon, Brakuku.
How are you doing? Don't worry, you see his face very soon. I'm just trying to
Sure.
polish him out
Right,
a bit.
right, right. Yes.
How are you
Yeah.
doing?
Yeah, I'm out and about, but I'll still have to pause and appear and engage. And so, in the midst of everything, we are here and now. Pleasure to be here.
Good. Once you say appear, then I try to see if I could use some of your legal jargons. You've been summoned to appear.
Someone for a good reason.
Thank you very much. Well, folks and people out there, Lawyer Charles Asma is our resource person. As I said, he will be helping us with the discussion that we're going to have how to successfully make an application as a spouse here in the UK. We'll be unraveling that. But before then, as I said, when somebody does something for you, you show your appreciation, and let's see who is appreciating people here within BWF solicitors. BWF Solicitors, as I mentioned, you can find us on the fourth floor of the other house. Our contact number is 0208 In Ghana, 055 589 5959. In emergency situations, 077 127 61884. Now, let's take the first one, the appreciation I was talking about. And, well, interestingly, it talks about our resource person this afternoon, Lawyer Charles Asma. Uh, Sasa says that Lawyer Charles Asma is very professional, kind, and has empathy. He pays attention to every detail and supports you holistically. We're very impressed and satisfied with the legal services provided for us. We remain thankful. Lawyer Asma, Sasa remains thankful. He says that you're very professional, you pay attention to detail, you're kind, you're very empathetic when they appeared before you, you supported them holistically, and they're quite impressed. What would you say?
We are grateful, Sasa, for entrusting us with your work and believing that we can help here at BWF Solicitors. And here at BWF Solicitors, what we do is to use the law and with all the words that have been put together by SASA to make sure that individuals like SASA and others are happy and are able to achieve the best. So thank you. And I say that at BWF Solicitors, we have you at heart.
Yes, definitely we have you at heart, and that's the more reason why every Saturday afternoon we spend time, 2 hours, of course, with you so we can go into some of the things that pertain to our stay here in the UK. Now, you may be working as a member of staff of any organization, and this will come to you. Let me see if you can look at this as a nugget. Earlier on in the week, this was put out. An employee may carry over some of their annual leave. Every worker is legally entitled to paid yearly leave. Workers have been allowed 56 weeks of annual leave since 2009. So,
5.6.
suppose a worker does not use all their statutory annual leave entitlement during the relevant year, what happens? In that case, we are told the employer can allow them to carry the unused days until the following holiday year. The worker must take at least 4 weeks of holiday per year. This means that 16 weeks can often be carried forward once into the subsequent leave year. If there's a written agreement between the worker and the employer, this can happen. And this was quoted from the Working Regulations of 1998, WTR. Now, talking about number of days, number of weeks, statutory leave, I mean that it has to happen. It is compulsory, I suppose. Maybe lawyer will clarify that for me. But if you have leave and you don't use all of that, what happens? Lawyer, please get us into this if you can.
Thank you very much, viewers and listeners. So, within the working time regulations of 1998, every employee is required to have rest. And rest here is the statutory leave.
Mm,
The law says that every employee must be given 5.6 weeks. 5.6 weeks. And at any point in time within the year, you can have at least 4 weeks off. What it means is you either have the entire 5.6 weeks or you have a minimum of 4 weeks off. And that's why most people would take 4 weeks and has become as a standard as though that is the maximum. No, the 4 weeks that most people get is the because 4 weeks work out 4, 7, 28, work out 28 days thereabout. Some do have 21 days. For example, teachers have 6 weeks and so on and so forth. But the bottom line is that every employee must have 5.6 weeks of annual leave. And this has been since 2009 within the Working Time Regulation of 1998. What it means is that if you decide to have the 4 weeks minimum, then you can carry forward the 1.6 weeks into the next year. If you decide to transfer or carry over into the next year, you have to have a conversation with the employer. The key thing is conversation with the employer. If you
mhm.
don't have the conversation with the employer with a view to carry over the 1.6 remaining weeks of your holiday, then it's deemed to have been forfeited. And so, even though you may have that extra 1.6, if there's no conversation with the employer with the view to transfer or save it for next year, you will lose it. And so, that 5.6 weeks is the standard.
Mm.
You usually will have 4 weeks within the year. But if you are not able to use the entire 5.6 weeks, then you have the right to carry over 1.6. But in carrying over the 1.6, please, you have to have a discussion with the employer so that the employer is aware that you have used the minimum and the remaining is to be saved for you for the next year. And that will add to the one to have next year, and so on and so forth. It's
Right.
a right. And so whether you know or not, obviously somebody says that what if I haven't had it last year and I now know, can I go and get it? If you didn't know and you haven't had conversations with the employer, then it is not deemed to have been carried forward into the current or the following year.
Well, from the Working Time Regulations, 1998 law, it says every worker is legally entitled to paid yearly leave, and since 2009, people have been allowed 5.6 weeks. Does it mean that if my employer does not give me the 5.6 weeks, then I have something that they are not giving me and I can demand it?
It's a right. Annual leave is a right. And
Mhm.
so it's up to you to assert such right. And the statutory limit is 5.6 weeks within every employment year. Now, every employer will give you time off. However, it should be within the accommodation window of the business. First accommodation window, what it means is that has to be reflect the business needs. If
Mhm.
everybody is taking leave days at the same time, then the business needs will be jeopardized. And that
Mhm.
is why the employer will not ask you to go for holidays for the entire 5.6 weeks. Because 5.6 weeks, if you work it out properly, 1 week is 7. And so, or
Mhm.
let's say 5 working days. So 25 working days and a half, which is so give and take, you're talking about close to 30 working days. You cannot have close to 30 working days off. What happens to your work? And that means there should be a cover for you for the entire period. And that's going to create operational costs. And that will affect productivity, affect cost, affect efficiency, and also affect profitability. And so the employers will not allow that. And that is why the law says that if it's not possible to have the entire 5.6 weeks, you can have 4 and carry over the 1.6. So that at any point in time, you can stagger the period and utilize it in a way that will benefit you and also benefit the business. However, if you decide to carry forward that 1.6 weeks, you have to have a conversation with the employer. But the employer cannot say that if for example you are going to go on leave, you have to pay for it, because who's going to pay for the cover and so on and so forth. It's a right, and that must be paid holiday or paid leave. So for the employee must be given the opportunity to take the break. For the employee must be paid whilst on that annual leave. For the employee, it's your right to have the period. However, it's your duty to ensure that there's the conversation with the employer so that it doesn't affect the business or operational needs of the employer's business. So it's a mutual conversation. Each must benefit, but at the same time, the employer must ensure that the employee is not disadvantaged.
Now, you mentioned that there must be the conversation between the employer and the employee if the employee wants to carry over some of the leave allowance into another year. Um, would there be the situation, or could there be the situation, so to speak, where the employer would say that I will, as a blanket rule, allow that whether you have that conversation or not, you can carry a certain number of days into the next year? Could there be a situation like that, lawyer?
Well, if the employee, the rule says that there should be a written agreement.
Mhm.
Now, if there is a written agreement with a view to allow the employee to carry over some or carry forward that number of days
Mhm.
within the entire leave period, it's a conversation. But to avoid confusion or disagreement, it has to be in writing so that both
Okay.
parties are clear. It's explicit that this has happened. But the thing is that it can be done with once in a year. So you cannot say, I carry it forward and I'm carrying and I'm carrying, I'm carrying. All you do is that you accumulate it. So accumulation of leave is also not allowed. And also in line with Health and Safety Act of 1974, wherein the employees are supposed to have break so that they can rejuvenate and support the efficiency objectives of the business. So you can't say, I keep carrying forward my break. And no, that will not also happen. That's why you can only do so once in a year.
Okay. So it must be written, but then it depends on which organization. The agreement or the discussion or the conversation should happen between the employer and the employee. Well, ladies and gentlemen, we have been looking at the working time regulations of 1998 and the leave allowance that workers are entitled to has been discussed. In that situation, let me see this scenario that my friend is facing. And let's see if we can find some correct answers for Kofi. And Kofi Brookman, as we say, a very hard-working cleaner at Umofia Groceries Limited, is contemplating carrying over his annual holidays to the following year so that he can have an extended holiday for 2.5 months. What advice would you give him? He should first seek permission from the employers before carrying over all holidays to the following year. Kofi must take at least 4 weeks of his holidays, and with his employer's permission, he can carry over the 1.6 weeks that he's looking for. Or three, Kofi cannot carry over any of the holidays at all. Which one will be the correct answer? Think about that. I'll come back to you at the tail end of the program, and we go on to that. So, yeah. Kofi Brookman, how do we help him? What answer will be the correct one to give our very dear friend? You can leave your answers in the comment section down below, either on Facebook or YouTube, or you can text it to us 07399208468. This is a community and the law, and we're taking a quick break. When we come back, we're going to our discussion straight away, where we'll be looking at how to make a successful spousal application whilst in the UK. Who's a spouse? What is spousal application? Why in the UK, not outside of the UK? The community and the law will be unraveling all these right after this.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. We're live on BWTV at BWF Solicitors Facebook, at BWF Solicitors YouTube, and also at BWTV Facebook and YouTube. This afternoon, by courtesy of BWF Solicitors, we're going to look at how to make a successful spousal application whilst in the UK. So I was trying to find out why in the UK, not outside. Who is a spouse? What is spousal application? And what are the steps and the very processes we need to follow when we're making such an application. And as I introduced earlier on, our very own Charles Asma from BWF Solicitors is here with us to help us go through this topic. Uncle Charles, spousal application, why in the UK and not outside? Let's unpick all these things and look at how we can do that.
Thank you very much. So, viewers and listeners, today we bring you spousal applications in the UK. We have defined this conversation so that it's clearer to viewers and listeners that we are dealing with applications in country, not from abroad. Now, applying from abroad is straightforward because you want to enter the UK to join your spouse. So that's quite straightforward. However, it's also possible that you can be in the UK and decide to apply to remain with your spouse. Either you were already married and you want to apply to be a dependent of that spouse, or you were already on a different visa and you have now married this individual and you want to switch, or you were an overstayer and you are now married to this individual and you want to switch, or you want to apply to regularize your leave as a spouse of that individual. I have used the word married. Now, the law does not limit this application to marriage, and so we define spouse within appendix relationship with a partner, paragraph RWP 6.2. It says that a partner is somebody whom you are married to or whom you have a relationship with. And that relationship is one that is akin to marriage. And that is where we say unmarried partner. So if the person is your unmarried partner, it means that you are not married, but you are in that relationship which has lasted for 2 years. You do not have to be living together to be able to sponsor that person. You just have to show that there is relationship. But if you are married, then it's quite straightforward. It doesn't matter how long you've been in a relationship. what suffices is the evidence of marriage.
If you said the evidence of marriage, if I am in a relationship with another person which is akin to marriage, and we have not married, you say that we do not necessarily have to be married because we could be in that relationship for at least 2 years and the rest of it. How do I prove a relationship that is not a married relationship, but rather akin to or has been subsisting?
Thank you very much. So we are actually looking at two things here. And so we'll look at applications for spouses. Applications for spouses, that is continuation of the person's leave.
Mhm.
An application for spouses, that is emerging from an overstaying period. So you can have a spouse who is applying to remain because they were first an overstayer. So you are living in the UK illegally and you want to remain with your partner. Can you do it? Yes, you can. You have been living in the UK with another visa or on another visa, i.e., student or post study visa or skilled worker. These are all valid leave. You want to switch from that to spousal visa. And here we are looking at spousal visas under Appendix FM to the immigration rules, because we have spousal visas that will fall under Appendix skilled worker, or spousal visas that will fall under Appendix student, or spousal visas that will fall under other categories. But for this conversation, we are saying that spousal visa application is one under Appendix FM to the immigration rules. And so the person is looking at Article 8 right with that family member who is their spouse, i.e., married or unmarried. Now, take off. So the key thing is the requirement within the rules, Appendix FM to the immigration rules. First thing is evidence of relationship under paragraph RWP 6.2 of Appendix relationship with a partner. The key word is relationship. And so relationship that is formalized or relationship that is not formalized. Formalized is the one that is converted and evidenced by marriage certificate. And not formalized is one that is going in terms of the conduct of the two parties, whether they are living together or not. Before they had to be living together, but at the moment the law says that they don't have to be living together, which is good. But how do you prove if you are not living together? It makes it a very high threshold in proving that, but it's still doable. So let's start off with the key requirements. Then we will look at those who are applying as overstayers and those who are applying with visas already in their hand. Which one has high chance of success? And what happens if the one that has overstayed is applying? Should they add something else? So we look at the requirement. The first is relationship. The second is the financial evidence, evidence that the person, the applicant, earns £29,000 or the sponsor earns £29,000 before tax, or combined income both £29,000 before tax. If the person is self-employed, then they have to show profit before tax is taken. Profit before what we call, so we have your turnover or income from business, you take out your expenses, and you have your profit before tax. And that profit is what you need to be able to show £29,000. So we've looked at the finance. The next stage is to look at suitability. Suitability is to do with the person's conduct, behavior generally, whether they have breached immigration rules in the past, whether they have encountered element of bankruptcy within the bankruptcy rules, whether they are indebted to the NHS from £500 and above by way of medical treatment that they were not entitled to, or they have had court proceedings with another party or the government, i.e., previous immigration appeal, and a cost is awarded against them and they haven't paid, or civil litigation cost is awarded against them, they haven't paid. If that cost is due the Home Office, then you owe Home Office. If you owe Home Office, that will also be a suitability factor. Or if you owe the court, that is also a suitability factor. So owing Home Office could be that Home Office has been awarded cost against you previously and you still haven't paid. Or it's also possible that you were supposed to pay certain court fee and you didn't pay. Or previous applications, you are supposed to make some payments as part of that visa application and you still haven't paid. It could be any form of debt, but if you owe the government, you, i.e., Home Office or any other government agency, the court or the health service, then that is a suitability matter. It will go against you. Again, if you
Before you go on, let me come on to this suitability issue. You're talking about your behavior, whether you owe any government agency. People have CCJs against their names. Would that be considered when we're looking at suitability?
It's more about bankruptcy than CCJ because
Okay.
CCJs may not necessarily be your fault, even though it's your fault that you didn't pay or you didn't pick it up. For example, somebody may have had judgment against them for non-payment of parking fine or ticket or anything at all, as paltry as £1 or as much as whatever amount. They didn't know because they've moved address. The next time they realize it's on the system as CCJ, they
Okay.
fight it, and the law says that if you don't pick it up within 28 days of the judgment, and it is recorded, you'll not be able to reverse it. The only way you can reverse it is if you go to court to say that I wasn't aware, and therefore, within the civil procedure rules, I wasn't given opportunity to defend the claim. And if you're not given the opportunity to defend the claim under the relevant part of the civil procedure rules, then we look at, for example, CPR 13, where you can go to court to tell the court that I wasn't given opportunity to defend, and so I should be given opportunity for fairness to be complete. Then the court will listen to you why you think you didn't have the opportunity. If the reasons are valid, then the judgment will be set aside so that you can have opportunity to defend the claim. But if you think that that is going to be daunting, then you wouldn't want to do it. You just let it go. But by letting it go, it will reflect on the system as CCJ. Even if you pay, it will be recorded as satisfied. However, it will show for 6 years.
Okay.
Now, within that 6 years, if you are going to apply or make an application to the Home Office and they are going to use it against you, come on, that may not be fair. And so CCJ is not a deciding factor for suitability.
Okay.
However, bankruptcy is. For bankruptcy, you have to go through the process to declare yourself bankrupt so that
Mhm.
your debt can be written off. Much as you are going to benefit from your debt getting written off, you may lose out when it comes to immigration, and especially if you haven't had your indefinite leave to remain.
To
You've
remain,
gone
yeah.
through that process. That will come up against you. Or you've been disqualified from driving for certain reasons. Those matters can come up during the application stages. And so you'll be asked certain questions, and the answer you provide will determine. But CCJ is not part of those suitability points.
Okay. Now, one of the suitability points was the amount of money you owe to the NHS, for instance, £500 and above. For instance, I owe the NHS £1,000, and I have made an arrangement with the particular trust to say that I'll pay you X amount of money every month. But then the balance at the time of my application is more than the £500. Would I still be penalized for this?
Now, you said something that is important. What is the difference between somebody who owes and has arrangement in place and somebody who owes and doesn't have any arrangement in place? What's the difference?
Now, the one that has an arrangement has intention to pay.
Good. So it's all about intention and commitment.
Mhm.
And therefore, if you have recognized your responsibility and taken active steps to remedy that issue, then that is fair. And so they are not asking you to pay everything, but they are asking you to show that you don't owe them, or you have a plan in place to pay it.
Mhm.
And that is all you say. They will ask you, do you da da da? Yes. Then you give what you have set out to do in terms of paying it. If that is the case, you are not, then your conduct is not bad compared to somebody who has ignored the fact that they owe a debt and they have done nothing to pay it.
Okay. So yeah, if you just joined us, we're looking at how to successfully make a spousal application whilst in the UK. And Lawyer Charles Asma, by courtesy of BWF Solicitors, is taking us through the various steps. We're looking at the definitional issues and the rest of it. He's mentioned two of the things that we need to satisfy, so to speak, to be able to qualify to make such an application. The first one we looked at the financial bit and the relationship you have with the person who you are making the application. We are looking at the suitability where we're talking about your character, so to speak. We've mentioned these two. Now, is there any other thing that needs to be satisfied before we can tackle such an application?
Yes, we're also looking at English language proficiency. And here the rules say that you must show that you will have proficiency up to, for example, B1 level. B1 level, give and take, is equivalent to GCSE level. And so if you're operating at GCSE level, your reading, writing, speaking, listening ability should be at secondary school level. That is the requirement. And so you're expected to, however, if you have overseas degree or you have UK degree, then you are likely to be exempted. If the overseas degree has been ECTIST. If I say ECTIST, what I mean is that ECTIST body has assessed the overseas degree and has given you a letter to show that it is equivalent to a UK degree. In this case, if it's equivalent to a UK degree and it was taught in English, then you have proficiency up to a degree level in English. So you don't have to write the English test again. Those are the exceptions or exemptions you may have for the English language. The next thing you have to show is accommodation. In
Okay.
accommodation, all you need is one room. In this case, you and your spouse will share one room, and that is it. Whether it's a big room or small room, they don't take the measurement. You just have to show there's accommodation in place. Even if the accommodation is provided by a friend or a family member, you just need a letter to evidence that. And under the Housing Act of 1985, Part IV, it says that the overcrowding concerns of the government should always be borne in mind in application processes. And so the type of accommodation it is and the number of people in the property will determine whether you have adequate accommodation. And so if you're applying to remain with your spouse, all you need is one room with your spouse, and that is enough evidence of accommodation. Now, we've touched on all the factors. What we're going to do in terms of making it successful is to open each factor, each requirement or criteria up and look at what needs to be evidenced to be able to make the application successful.
Okay. Yeah, that would be quite useful. So those of you who have joined us on Facebook and YouTube, you have the opportunity to put your questions down even before we get to the nitty-gritties of what each criteria is asking for. And also you can all text us on 07399 208 07399 Kwesi is asking, so you can use your GCSE English qualification. He's asking, when we get to that criteria, I'll open it up. We'll bring up your question again. So keep them coming. And help us with that discussion as well. Remember, we're doing this courtesy BWF Solicitors, fourth floor of the House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340 or in emergency situation 077 127 61884. I have lawyer Charles Asma with me, and if you would want to contact him directly, you can call him on 07937 07947, sorry, 636037, 07947 636037, and you can reach lawyer Charles Asma directly. He is on hand to help us have this discussion. So let's pick them one after the other, as you mentioned, and look at all the criteria and how we can meet them so we can make a successful application.
Okay, right. So all that we are going to mention will apply to those applying in country, whether they have a visa and they are switching, or they have no visa but they want to try for the first time to remain with their spouses. Now, the extra bit will be for those who have overstayed. So if you have overstayed, the case law consideration will apply to you. If you haven't overstayed, then the case law consideration will not apply to you. And also the EX1 of paragraph EX1, EX2 consideration will not apply to you. Now, let's go to the criteria. One, we look at relationship. How do you prove relationship? One, you are married. So if you are married, then you must be living together. That's the first bit. Now, marriage, somebody will say, if we are both in the UK, how do I show the marriage evidence or demonstrate the marriage? Is it marriage in the UK or marriage from abroad? And if I have to marry from abroad in my country, for example, do I have to travel to my country to get married to my spouse and return? But how do I return? For example, if I'm an overstayer, and so if you are not an overstayer, you are likely to return. But if you're an overstayer, then it's difficult. What about somebody who has already evidenced marriage? Then we are looking at, for those people, they have to show that they have first divorced before they can demonstrate that they've remarried, and this is the sponsor or spouse sponsoring them. Marriage. According to the rules, the government of UK has said that if the marriage is valid in the country of origin of that party, in other words, the country in which the marriage was contracted, then it will be acceptable in the UK. That means, insofar as that marriage is valid, valid means you've gone through the marriage law process to ensure that the marriage has been contracted validly, then it will be acceptable in the UK. For example, I'm just going to mention, as by way of case study, there are different countries, but if you look at Ghana, for example, there are two aspects of marriage. There's ordinance marriage and customary marriage. The Matrimonial Causes Act of Ghana, within the spectrum of the 1884 to 1985 Marriage Act or laws, has two aspects. So we have the traditional or customary marriage and also the ordinance marriage. Ordinance marriage rules will tell you that after the marriage has been contracted at home by the families involved or families of the parties, it has to be registered. But if it's under ordinance, then both parties must be present to sign. Present to sign. So we're looking at physical presence. So if one party is not, then they cannot have ordinance marriage. But there's another marriage, we're looking at context of Ghana, where customary marriage provisions allow for those parties who are not physically present to have family members representing them, so that at the registration stage, the family members will have to declare at court under statutory declaration to show that they represented the parties. and that will suffice. So if it is under customary marriage, we're looking at the marriage certificate, we're looking at the statutory declaration by the family members who represented them, and
Mhm.
also the judicial service letter to confirm that the marriage has gone through the court process, and also Ministry of Foreign Affairs letter to show that this marriage is valid in Ghana, for example. And remember, the UK government says that if it is valid in the country in which it is contracted, that it is accepted in
Accepted
the
in the
UK or
UK.
acceptable in the UK. So
Mhm.
that is one part. Now, again, under Ghanaian marriage laws, it says that parties can register their marriage anytime after marriage. What it means is if you married a year ago, you
Mhm.
can register it today. So registration is not compulsory. It only becomes useful if you so desire to register it. But the marriage has already taken place, and so
Mhm.
marriage is between families. But because there's no evidence of whatever happened between the families except the words and the photos, you want official declaration or evidence. And that is why registration is allowed within the rules. But you can register whenever you prefer. And for example, if you look at Section 2 of the Marriage Act of 1884 to the 1985 of Ghana, it says that parties, one or both, can declare intention to register, and they have to notify the marriage registrar to get the marriage registered after the marriage has already been contracted. So
Contracted.
that is one aspect. In this case, if you are not present physically in your country and your country's marriage laws allows for you to be represented by families, then you can be in the UK and have the marriage performed by your family members, represented by those family representatives, and you go through the registration process to get it done. So
Now,
that is the,
in the context of the Ghanaian marriage that you are talking about, like, the registration doesn't necessarily have to happen in Ghana, or they could bring the evidence of the marriage here to the UK and get it registered.
now in the UK. Where can you register your marriage if it's a Ghanaian marriage?
Well, it has to go to the council. Why I'm asking that question was that uh, the UK would accept that that marriage has properly taken place in Ghana. So would they accept to register it once there's evidence that it's properly taking place in Ghana?
If the marriage took place in Ghana, Ghana, for example, has the entire country with its systems
Mm-hmm.
and a silo body, which is called High Commissioner in the foreign country.
Mm-hmm.
So if it is to be registered, which places should it be registered? Is it the registrar within the wider country or the silo body in the foreign jurisdiction? For me, I think you have to register it within the wider body. And that is where um, I don't see why the person will bring it to the UK to have it registered. On what basis are you making the application? On what basis are you going through? So even though the commissioner has power to do certain things, registration of marriage ought to take place because the marriage took place not in the UK. It took place in that country, I suppose, isn't it?
Yeah. So the people who stood proxy for you can register on your behalf.
So the registry, you are not registering on your behalf. You are authorizing the registration.
Okay.
And authorizing registration, of course, there's no rule to say that come physically to pick a form to register. It says register. Whether you
Okay.
call, you make a phone call, or you send email, as long as you've gone through the formalities to get it registered, that is registration. What it means is that you can ask, you can authorize a family member to
Mm-hmm.
have the process gone through. One thing I will mention though here is this: the certificate ought to be signed by both parties, and so it cannot be signed for. Both parties must sign. So somebody will say, so how will both parties sign? It's possible that once the registration has taken place, the opportunity for both parties to sign will be offered. And you can't sign remotely. What it means is that they have to let you receive the document get it done in terms of the signatory, send it back to the body for them to confirm that it's been signed. Signature is checked against another signature you have on an ID document. And once the registrar is satisfied that the processes have been followed to the letter, then it becomes a valid marriage in terms of the registration of the marriage.
Okay. All right. So that's satisfied. We're looking at the relationship as you mentioned. Um, we have proven that the marriage or the relation subsists. What else do we do?
Good. So the rules say that the relationship, it doesn't say marriage, it says the relationship should be genuine and subsisting. It's easy to prove that it's genuine. If you are married, you show marriage certificate. But if you are not in a relationship, if you are not married, how do you prove that it's genuine? And that is where we have a whole range of peripheral evidence. I call them peripheral evidence because they corroborate your point or your word that there is relationship. Now, if there's relationship, there will be communication. If there is relationship, there will be support. If there's relationship, all aspects of things that support the relationship to be subsisting will have to be made available. Subsistence simply means that it is ongoing. So you can't say that we are in a relationship and yet, if it's a case of marriage, they are living apart. It's possible somebody will say that because of work, I live here and the family lives there, or my partner lives there, and so we don't have evidence of living together. But you definitely if you are living with your partner, then obviously there will be some trace of living together, proof of address, common proof of address. And that is why most people will say that I came to the UK with my spouse, and because of work, we stopped living together, and yet we are still living together. They will tell you that the relationship is no longer subsisting. So, photographic evidence just to demonstrate that life is going on. Evidence of support could be money transfer, but if you are both living together, then you don't really need money for each other. If, for example, there's no need to transfer, what about if you are giving cash? So certain things is difficult, and so you have to look at other factors that or evidence that will support your claim. And so commonly we are looking at things together, such as communication, things together, for example, insurance, things together in terms of owning assets, things together in terms of certain activities you have or you do together. All this will support your claim that your relationship is ongoing. If it's ongoing, then it's a matter of time and chronology. So if you bring one piece of evidence to show that it was there in, let's say, 2021, and you are applying in 2025, and you cannot demonstrate that there's still something to show, then conclusion or the presumption will be that there is no subsisting relationship, or the relationship is not longer there. So you don't want to give room to the caseworker to form their
Mm.
own presumptions. Otherwise, it will be difficult for you to rebut. So go with it right from the beginning. The next stage is if you are not living together. If you are not living together, you don't have proof of address because the law says you don't have to be living together
Yeah.
if you have been in a relationship for 2 years. But how do you evidence it? And that is one that is quite difficult to demonstrate. So you have to include everything we have mentioned except proof of address and the marriage certificate. Somebody will ask, photo, is it enough? Photos alone do not prove relationship, but they support the claim that there is relationship. And so it's not just enough to show photos. It's important that you have a range of other corroborative evidence that we
Mhm.
have talked about. The next is the English. I think we've already talked about English language. So let's move on to the finance. In
Mhm.
terms of finance, you have to show pay slips. You have to show bank statement. How many months? Is 6 months up to the date of application. Now, if you've been working, you can also add your P60. Also, a letter from the employer to confirm that the person earns 29,000 gross. That is before tax. And this can be If you are doing two jobs, both jobs can be put together, but there's a criteria to do it. For example, we have category A, evidence of income, category B, evidence of income, and category C, evidence of income. All will go towards showing that you earn 29,000, either from your income as individual applicant, or from your sponsor's income as individual sponsor, or from your combined income as parties or partners. So all these are permissible. There's a rule to it. So let's just bear that in mind. What
Yes.
if the partner is disabled? Is it still compulsory to show the finance? No. If the person is disabled and they are receiving personal, individual, personal individual payment, yes, personal individual payment, that payment ought to be the case to exempt you from the financial threshold. So if the person is disabled and they are receiving disability benefit in terms of PIP, then they do not have to show that they are working.
Okay.
If the one party is working and they have enough, fine. If they don't have enough, the PIP will support the claim that they should be exempted from the finance. So we've seen instances where finance can be exempted, and we have understood that when the person is on PIP or certain other categories of benefit, it will be acceptable. Now, my advice to viewers and listeners is that if you can show the financial threshold, 29,000, by combining your income, unless you can't control it or do anything about it, then you go for the exemption or exception. Okay, we'll move on to the third category, which is accommodation. We've already touched on accommodation. Accommodation here, you have to show tenancy agreement. You have to show a letter. If there's no tenancy agreement, a letter from the landlord. If somebody is helping you, or you are lodging with a friend or a family member, then a letter from that family member supported by their ID and supported by evidence that they have power to give you accommodation at that place. And
Now,
here again,
if you talk about accommodation, let me get this little clarification. Now, somebody has rented a three-bedroom apartment. The person is living with their partner in the same apartment. You are making an application and you have been given a room in that apartment. You mentioned earlier on that you only need one room because a spouse can live in that room. In this case, the three-bedroom apartment, the supposed person who has rented from another landlord is living in one room and they have given you one room. Two questions. Is the accommodation not overpopulated or overcrowded? And secondly, does the person who has rented from a different landlord have to have permission from that landlord before they can give the applicant a letter to support the application?
so what you are asking is what qualifies as overcrowding in that
Mhm.
property.
Yeah.
For the property to be overcrowded, the law says that each adult or each person, not adult person, each person over the age of 13 years will require one room except their partners.
Okay.
So let's say there are three rooms plus the living room, making four rooms.
Okay.
Each room is occupied by an individual tenant. This friend of yours has two rooms there. The living room, which is part of his the bit that he has taken up. And so
Mhm.
he has two rooms. He's using one and he has given you one, you and your partner. That is accommodation because it's a room that is not shared with any other adult except your partner.
Okay.
Question: what power do you have to be able to live there? Are you a tenant or you are a lodger? It comes across that this case study client is a lodger lodging with a friend or a church member or whoever it is. So the host will have to provide a letter. Question: do I have to go and get a letter from the landlord? The landlord has already forfeited the benefit of the property temporarily by way of tenancy agreement. And therefore, your friend whom you are lodging will give you the tenancy agreement to show that they have proprietary right at this stage to be able to allow you to live with them.
Okay.
And they will add their ID, proof of ID copy, to show that this is this person. This is the evidence that the person has rented the property. The property is 2 rooms in a shared accommodation. Those 2 rooms, he is using one, and the spare one, he's giving it to you and your partner. And this is a letter to support that. That is enough evidence of accommodation. Or
Yeah.
your own rented accommodation. In this case, you have to get a tenancy agreement. Question: what sort of tenancy agreement? We
Mhm.
have standard tenancy agreement where the estate agent will, through the land with the landlord, will provide it for you, signed by both parties. Or you can get one from the post office, and it's written at the top, tenancy agreement. That is also within the law, evidence of tenancy. So either way, there's opportunity for you to demonstrate that tenancy agreement you have if you are a tenant. Otherwise, if you are a landlord yourself, then you need your mortgage papers or the land papers to support that. So we have all these 3 options to demonstrate the accommodation bit.
Okay. Then you mentioned that the person is lodging with the friend. Lodging to the ordinary person would mean that, well, you're doing me a favor, so I'm not paying rent at that time. But if you have rented from somebody and you've sublet another of or the room to another person, and the person is paying rent to you, so you add up to your bit and pay the landlord, would that suffice as enough to add to the application, so to speak?
Right. I mean, remember within the rules or the laws covering tenancy in the UK, you cannot sublet. And it will be within
Okay.
the tenancy agreement that you shall not sublet for all or part of this property to another. And that would be breach of the tenancy agreement. But the rules don't say that you cannot show kindness. It
Okay.
says what it means that subletting is with a view to pass off, gain out of that agreement without the landlord's consent, and that is illegal, unlawful.
Okay.
But if somebody is genuinely in need and you are a human being who has empathy and you are helping, then you just have to show that this person is the one helping you. They have permission to be there because they are tenant, but there's room available, and that room they've given it to you temporarily, you and your spouse, and they have provided the evidence and the confirmation that yes, this is the case. That's fine.
Okay.
Now, question: if you are lodging, then we don't expect you to pay rent, but you may be contributing to bills. That is equitable.
Okay.
That's
And
fair.
the bills could be the rent, electricity,
No,
gas, and all that.
but remember we said if you are lodging, you do not necessarily have to
You have to pay
contribute to
rent.
rent, but you contribute to bills. You don't pay the rent. So if you say I'm contributing to rent, then so to speak, you are paying rent. But what we are saying is that you are contributing to the bills. So whilst your host is footing the rent entirely, you are contributing to water, electricity, the amenities,
Okay.
including council tax. That's fine, fair point.
Okay. All right. Well, moving on, let's see what else we could have as part of the criteria. Are we looking at well, you mentioned the English language. I think let me quickly touch on that. It's a brief point though, but let me quickly touch on that. There was a question from one of viewers talking about the English language being equivalent to the GCSE qualification. So Kwesi is asking, can you use your GCSE English qualification for the B1?
Fair point. Because B1 is equivalent to GCSE.
Mhm.
Um, for me, you see, the case workers may not understand the nitty gritties. If I say they may not, I use the expression carefully, in that if the case worker gets it wrong to refuse an application, it means they misunderstood the criteria for assessing the application in the first place. That's why we go for judicial review, and that's why we go to court. So as far as possible, and if you can, please make it easy for the person. They say degree, bring degree if you have it. Or if you have GCSE and you want to use it, okay, what if the person does not get it, does not understand that GCSE can be used? Then can you just go and do the B1? I said that if you can, just go and do the B1. It's so easy, so that it settles matters from the outset. But GCSE, if you use it and the caseworker understands that it's equivalent to B1, then they may accept it. I use the word may.
May. Well, if you just joined us, we're having that wonderful discussion on how to make a successful spousal application when you are still in the UK. Laura, my question would be, having looked at this criteria, we've satisfied finance, we've satisfied accommodation, we've proven relationship, we have our English language. Does it then become a tick box application because I've satisfied all that, but or it'll still be at the discretion of the caseworker?
Thank you. Now, if it's a discretion, then there should be no boxes to be ticked.
Mm-hmm.
And because they've told you to meet the following criteria, if you're able to meet them, caseworker must honor them.
Okay.
It's not point for discretion. Point for discretion only comes in when exceptions apply, and we'll come to the exception shortly. So once you've met the criteria, the caseworker must grant. Because it says that if XYZ are met, caseworker must grant under decision criterion within the rules.
Okay. So the onus is on the applicant to meet all the bits in the criteria.
That is, if you want to ensure that you have no case to answer in terms of giving opportunity to the caseworker to use discretion. Discretion simply means that you don't meet the rules, but should I grant it?
Yeah. Okay. Okay. I get it. So that aside, what would be an exception in this situation, Laura?
Thank you very much. So the exceptions will be, for example, we've mentioned that somebody does not meet the English, does not meet the financial threshold, and we've explained what they can do to mitigate that in terms of the exception to the English language.
Mm-hmm.
For relationship, the exception is being in a relationship for 2 years. Otherwise, it should show marriage certificate. And in terms of subsisting relationship, we've covered a range of life-based activities that can be evidenced: life insurance, owning property together, communications, and all those places that you visit, and all that you can evidence them to say that this shows there's subsisting relationship. Now, the point here will be for somebody who cannot meet the requirements. In other words, the person is not switching. If you are not switching, it means you don't have visa already. You are not a student that you say that I'm now married or I'm now in a relationship for 2 years, so I want to convert from student visa to Appendix FM visa as a spouse.
Okay.
You don't have post-study leave visa to say that I now want to switch from post-study leave visa, post-study, which is the visa, post-study visa to spousal visa.
Mm-hmm.
You don't have skilled worker as a main applicant without a partner to say that it's not expired, but I want to convert because I have now married somebody who has indefinite leave to remain or who has British citizenship. Now back to who qualifies as a spouse. We have a qualifying partner within the rules. A qualifying partner is somebody who can sponsor your application, and the person must be someone with indefinite leave to remain, either indefinite within the general indefinite criterion or EU settled status indefinite, or the person has EU citizenship with 5 years pre-settled status. That's also possible. That's a qualifying partner. So British citizenship, indefinite leave to remain, or EU with 5 years, you are a qualifying partner. A qualifying partner can sponsor a dependent or the other partner to remain with them in the UK to have a family life under
Okay.
Article 8. Now, this person, even though the sponsor is a qualifying partner, you do not have leave. You are an overstayer. And it doesn't matter how many days or months you've overstayed, you are an overstayer. If you don't have visa to remain in the UK and you are applying to remain with your spouse, question will be, are we talking about two adults? There's no child involved. If there's no child involved, what they will tell you is that go back to your country with your sponsoring partner if it is based on love. Because, so to speak, you are applying to remain with your partner so that you can have life. Visa is secondary. And so, if it is about life as partners, then they will ask you, it doesn't matter which part of the world you live to have your married life or family life, go to back to your country. And if you so love this person, follow her or follow him to the country and stay there and have your life. So when it comes to an applicant without leave to remain or without stay, it's difficult because they will tell you both go back. What if the applicant wants to stay? What must the applicant show? The applicant who is an overstayer can show that their partner, the sponsor, has a child. And the child is a qualifying child, i.e., a British citizen, a child who has pre-settled status as a EU national, or a child who has settled status or indefinite leave to remain, or a child that has lived in the UK for 7 years, either born in the UK and has lived for 7 years, or born abroad and has lived in the UK for 7 years. All this will pass the test or for the qualifying child. So if you have a qualifying child and you now married to this sponsor, you become a step parent to this child. And if you are applying without leave or you are an overstayer and you want to remain with your partner, then you also say that I want to remain with my partner and my stepchild. The reason is that, yes, I can go back to my country with my partner to have our lives as adults, but the child will suffer because the child cannot leave the UK. And therefore, consider the child under Section 55 of the Borders Act and let the child stay so that I can be here and to support in caring for the child. That will be in the paramount interest of the child for you to be granted. So that's one of the exceptions.
Okay.
The next one is that there's no child involved who is a qualifying child. In this case, and mind and coming back to the step parent threshold. The step parent, that is, if you are married to the other parent, or you've been in a relationship for 2 years with the other parent, you still qualify. So we have de facto step parent and legal step parent. So legal step parent, you are married. De facto step parent, you've been in a relationship for 2 years with the child's other parent, and so you are a step parent. So that is the clarification. Now, there's no child involved, and therefore there's no consideration of Section 55. Then, if you are relying on your own self as an adult to prove that if you are sent back to your country, your life will be at risk, then you have to show the exception under EX 2B of um, the rules, paragraph EX 2B, the exceptions. Now, with this one, it says that if the adult applicant does not meet the criteria, then they must show that there is insurmountable obstacle to their relocation to their country of origin. And what suffice to be insurmountable obstacle? The case law, the case of Bat and the Secretary of State, the case of Chikumba and other supporting cases are saying that if the person cannot have the opportunity to apply and return where the person will be granted the visa, then it's not a case of exception. They cannot stay here and be granted. Or if the person doesn't have any life-threatening issues, wherein if the person relocate to their country, it will bring untold hardship, then there's no insurmountable obstacle. Or if the partner doesn't have issues that will bring untold hardship, there's no insurmountable obstacle. Example, you are an overstayer, you are terminally ill, you are married to this sponsor who is a British citizen. He is the one looking after you. You've been away for how many years? 10 years, 15 years, 20 years. Of course, if it's 20 years, you could have applied under private life. So not 20 years yet, but substantial years. And so you've severed relationship with your country or ties with your country of origin, i.e., most of your families are even dead. You don't even have all your friends, you don't have any connection. Then when you go back to your country, you struggle to integrate or reintegrate. The next thing is, if you are sent back and this terminal illness, you are not able to get the treatment that you are getting in the UK, then it will not be fair for you to be sent away. That will bring untold hardship. Now, this time it is not you having that medical condition, it's the sponsor partner. If the sponsor partner is the one who is unwell, and mind you, the sponsor partner is British, so the sponsor partner cannot be forced with this ailment to relocate because they are following love to that country. So we look at if they go, what's going to happen to them? They are receiving treatment. If they leave, if the person says that my wife or my partner, whether it's man or woman, should leave and I will be here alone, this is the one who is helping me. So how will I cope? It's about emotions, it's about support and all that. How will I get it? Somebody will argue that the council is available to provide that support. However, the council will only provide the physical support and aspect of emotional support. But there will be emotional support that will be consistent and that can only be provided by this family member. Would that be possible for it to be considered that if that is taken away, you may struggle to survive? And that may even cut short your life expectancy left on earth. And so, can that be considered as an insurmountable obstacle? If all these are put together, properly packaged, and argued out within the case law and within the statutory provisions and within the secondary rules, then the person will be able to evidence that even though they don't meet the criteria we have mentioned, they don't have a visa, then they have to be considered under the exceptions, because without considering the exceptions, it will create untold hardship. Then we are looking at proportionality. The aim of the government is to ensure that those who qualify remain in the UK, i.e., those who have leave to remain in the UK, and that it will be in the public interest for those people to remain. If you don't have any suitability issue, any criminal issue, or anything that is disingenuous or that is detrimental to the public, then there's no public good argument. And so it appears that your life is conducive to the public. However, should we say that because your life is conducive to the public, we should consider you to remain in the UK whilst we want to control immigration? Then we have to balance the duty to control immigration against your right under family life and look at whether it is proportionate for you to be sent away, considering all the points we've raised, the hardship element, the family element, and your good character. If it makes sense that in weighing the duty to control immigration against your right under Article 8, it is disproportionate for you to be sent away, considering the hardship element, then the decision to refuse will be inappropriate or disproportionate under the rules, and then you can fight it off in court. So all this ought to be put together, weighed against each other, packaged properly for those people who have overstayed and they want to remain in the UK with their spouses.
And with this, I will want to say, as I do say all the time, that if you want things done for you properly, especially when it comes to immigration matters, your bet sure, your sure bet, sorry. Your sure bet is BWF Solicitors. They are on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. N15 4P is the postcode. If you're using public transport, get onto the Victoria line on the underground, get off at the Seven Sisters station, use exit number 2 from that station, and it'll bring you to the front of Anna House. Climb to the 4th floor, and you meet BWF Solicitors. Or you can call them on 0208 493 7340, 0208 493 7340. If you're outside of the UK and you need any emergency advice or support, you can call 077 127 61884. 077 127 61884. Or you may want to speak to Lawyer Charles Asma directly. Call him on 07947 636037. 07947 636037. BWF Solicitors are trusted partners when it comes to the law. They bring us the community in the law every Saturday afternoon between 4 and 6 p.m. UK time. Now we're going to take a break, but before then, look at this. You are employed by an organization and you would want to ensure that you insist on your rights. Leave. An employee may carry over some of their annual leave. Every worker is legally entitled to paid yearly leave. Workers have been allowed 5.6 weeks of annual leave since April 2009. Suppose a worker does not use all their statutory annual leave entitlement during the relevant year. What do they do? In that case, the employer can allow them to carry the unused days until the following holiday year. The worker must at least take 4 weeks of holiday per year. This means that the 16 weeks can often be carried forward once into the subsequent leave year if there's a written agreement between the worker and the employer. This is from the Working Time Regulations of 1998. With that, I asked you about my friend Kofi, who wants to take part of his leave into the next financial year so that he could have 2.5 months of holiday at a stretch. What does he have to do based on this? Think about that. We'll take a break, and when we come back, we'll be taking your questions. The lines are active, 0208 493 7345, or you can send a text to 07399 208 468, or you can put that in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and we are live on BWTV. We're bringing you the community of the law, how to make a successful spousal application whilst still in the UK. Our resource person, lawyer Charles Asma, is still around and is going to help us. Listen, we're doing this courtesy BWF solicitors. Love United stands 5. Oh, that's an interesting name. Hello, good evening. I wanted to ask my husband, my husband lives abroad in Ghana, but he's a Nigerian. Would he have to go back to Nigeria to file to do the TB test, police report, and renew the passport there, or can do that all in Ghana? Lawyer.
These are some of the gray areas.
Mm-hmm.
And when there are gray areas, we can only test to see what is in the mind of the caseworker when confronted with these gray cases or gray area cases. This is somebody who is applying to enter the UK. The spouse or partner is in the UK. The person is Nigerian but resident in Ghana, or is from another country, resident in another country. So the passport shows that they are not a national of the country in which they are living.
Mm-hmm.
Now, the rules will say that when you are applying, of course, you mention your country, but it will also ask you, where do you want to do or have your fingerprint?
Mm-hmm.
You have to select. So if you enter your country of origin, it will give you the TB test locations in that particular country, not another country. And because the person is holding a Nigeria passport or Nigerian passport, they can only say that they are they are, or the person can only say that he is a Nigerian or she is a Nigerian. Now, once you say your country is Nigeria, the system will populate and look at places in Nigeria where you can have your TB test. And such places will not include places that are only located in Ghana. So the question is, can I choose a place that is identified in Nigeria because I'm a Nigerian and still abandon that place and go and have it in Ghana because I live in Ghana? You cannot. All you can do is you apply, choose, and when it's time for your fingerprint, travel to that place in your country, have it done, go back to where you are residing in Ghana, and when your visa is ready, go and pick it up. And you can travel from Ghana if you want, or you can travel from Nigeria supposedly. Okay?
Okay. Yes, keep them coming through. The lines are active 0208 493 7345, or you can send a text 07399208 or keep them in the comment section down below, like others are doing now. We're live on Facebook and YouTube at BWF Solicitors and at BWTV. Can my spouse access healthcare and other public services once the visa is granted?
If the person is granted the visa with recourse to public fund, they can. If not, they cannot.
Right. Lydia, well, that's that for you. Let's speak about another one. As I mentioned, I want to repeat the lines are active, so you can call it. What happens if you want to move to a different location within the UK during the visa process? Do we need to inform the Home Office? And how do we update our details?
This is straightforward. It is not compulsory that because you have applied for a visa, if you've gotten a cheap tenancy, you don't go for it. You go for it. So you are living in address A, in country in a city A or town A, and you've gotten another one. All you have to do, remember, if you are waiting for the visa, Home Office will not post the visa to you because the visas are not posted. They will email it to you. So the decision will be received by email. And whether you've changed your address or not, or relocated or not, the email will be the same email. So that is not a problem.
Hmm.
In terms of your passport, if you did it through your lawyer will receive the passport and let you have it. If you did it yourself, then all you have to do is, now that you have moved to a new address, make sure you have redirection in place with the post office for at least 1 year, so that once the decision is made within that period that you have moved to another address, the passport posted to your old address can be redirected to you at your new address. That is how to get around this. You don't have to tell the home office that I have relocated or have moved. If you want to tell them, you can tell them, but I'm sure you struggle to get in touch with them. So let it, it can, I mean, some people move and they're able to go back to the old address to pick their letters. If yours is one of them, you can always get your letters or you redirect and you have it at your new place.
Yes, let's pick another one quickly here. And remember, I've given you a scenario for you to consider. So think about that whilst we take the questions and comments from other people. Christia Bay is asking, how long will the spousal visa be valid? And what is the process for extending it or applying for indefinite leave to remain loyal?
Right. So the visa will be valid for 2.5 years, and you have to renew it for another 2.5 years. And once you've had it for 5 years, you apply for indefinite leave to remain. What's the process of extending? The process of extending is the same as the process of applying for the first one. So if you know how to apply for the first one, then it's the same way to renew it or extend it.
If you know how to apply, but if you don't know, don't worry. You can visit BWF solicitors and they will help you through various applications that you can make. Remember the number 0208 493 7340 or visit them on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. We're still taking your calls, we're still taking your questions, we're still taking your comments. Love United Stands 5 says, thank you so much. Thank you too. And I know that if you have any further issue, as I mentioned, you contact BWF solicitors. Sally is asking, how much is the home office fee and the IHS fee when it comes to spousal application?
The fee currently is £3,910. £3,910. The IHS fee is still £2,587 50 pence. And the visa fee has gone up by £63. And that is why it is now 3,910 instead of the one before, which was 3,000. £847 50 pence. So all you have to worry about is at least you have your budget of 3,910. If you are doing it yourself, of course, that's all you need. If a lawyer is doing it for you, then depending on the lawyer, you may have legal fees to pay as in addition.
In addition. So, Sally, the basics have been given you, but I would always say and repeat that it's always best for a layman to give his work for an artisan to do for them. Let's keep bringing your questions in. Your text number, as I mentioned earlier, 07399 208 or you can call in on 0208 493 7345. Earlier on, we mentioned that people are appreciating BWF solicitors for all the wonderful things they are doing for them, and I would want you to also do that. But in the meantime, yes, Sa mentioned Lawyer Charles Asma, who he said was very professional, kind, and has empathy. He paid attention to every detail and supported them holistically. We're very impressed and satisfied with the legal services provided for them. They remain very thankful, and I put that to Lawyer Charles Osman. You can also do that. Go to Google and give your reviews, or you send an email to admin at bwfsolicitors.com. Admin at bwfsolicitors.com. The scenario I gave you was based on the nuggets that we provided earlier on from Working Time Regulations of 1988 WTR, where an employee is entitled to 5.6 weeks of annual leave. So suppose you do not use all the statutory annual leave, you not want to lose that entitlement. What do? You can carry over part of it to the following holiday year. The worker must at least take 4 weeks of holiday per year. So I'm asking, if my friend had a situation where he wanted to carry part of his annual leave to the following year to have 2.5 months stretch of holidays, was he going to do? What advice would you give Kofi? You should first seek permission from his employers before carrying over all the holidays to the following year. Or are you going to tell Kofi that he must take at least 4 weeks of his holidays, and with his employer's permission, he can carry over 1.6 weeks? Or you tell Kofi, well, you cannot carry over any of the holidays. You're beginning that time, so spend it within the financial year, and that's it. Is that what is going to happen? Well, we're taking a quick break. Kofi Bukwan, don't worry, we'll come back to you. We're taking a quick break, and when we come back, we'll look at our questions, get the explanation, and if there are further questions, we'll put them to Lawyer Charles Asma right on the program. It's the community and the law. A very quick one, and we'll be back.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Show starts at 6 p.m. with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP. Includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexachampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing, and hosted by Alex Achampon. It's guaranteed to be awesome.
Yes, we're back, and we're going to go to quiz question. But I have two more questions for Lawyer Charles Asma, and before we go, sorry, another question. Does Love United stands fine? I was told that there would be a review for the spousal visa to increase or decrease in June. Is this true? It says, how long is good enough to show WhatsApp communication for a 5-year span, please, between the spouses who are in a long distance relationship? Now, I think there's a double barrel something from Love United Stand 5.
Yeah, so he said that there is a review for June. I
I
have to
guess
check
he's trying to talk about whether the fees are going up or down.
whether the 5 years is going up or down.
No, the fees, I mean.
The fees. Well, the fees go up all the time. If the government
Oh.
dreams of changing the fee and it's reasonable, it will happen. If it's due for you to make the application, please do. But I can't tell whether it will go up. I was told that there will be a review for spousal visa increase or decrease in June. Is it true? I don't know whether there will be, and if there's going to be, how much will it be? I can't really tell, so I can't be factual in my response. And because of that, I will not dare to respond in a way that will assist. But please, let's wait and see if there's going to be a review. If you are due, do it now. If you are not due, then there's nothing you can do, even if there's going to be a review. Okay. How long is enough? Communication history for 5 years span, please, between spouses. Of course, long as you have is good. If you have 5 years span, that's even better. Showing that over the last 5 years you've been, and that shows that at least you've been in a relationship for.
There's a very interesting scenario that can play out here. I've been in a long relationship with somebody for 5 years. We talk every day. We exchange messages. That would be thesis if I want to print and put them together.
I agree. How much of it do you put together
Yeah.
is, but how do you judge how much you put together? Is it a 6 months before or 6 months recently or currently, or the first 2 years or the last 2 years? How do you gauge? The more, the better.
Okay. The more the better. Um, let them know that your relationship is brilliant. What are the requirements for someone who wants to sign for someone for their British naturalization? Fred is asking.
There's no requirement because this is not lawful.
British naturalization. I guess probably somebody who will be used as a referee. I don't know whether that's what
Oh,
is
okay. Then let him come back because you can see that it's ambiguous, and I don't want to get my response wrong. So, Fred, if it's about reference or referee, please be specific because signing has different connotations and can be lawful or unlawful depending
Mm,
on what we are signing for.
okay. All right. Okay, so with that, we put off the questions. Fred, if you have any further thing, please drop that in our text or in the comment section down below. The answers to the scenario I presented you. Kofi Brookman, hard-working cleaner at Umofia Groceries Limited, is contemplating carrying over his annual holidays to the following year so that he can have an extended holiday for 2.5 months. What advice would you give Kofi? He should seek permission from his employers before carrying over all his holidays to the following year. Kofi must take at least 4 weeks of holidays, and with his employer's permission, he can carry over the 1.6 weeks. Or are you going to say, Kofi, you can't carry anything to the following year? Somebody sent me a text to my private phone. It was a very interesting one. He says, Kofi should not go on holiday. That's all. Well, Kofi should go on holiday. It's statutory. And for his own good and for the good of the organization, Kofi is entitled to take leave. So you can't tell Kofi not to go on holiday. He should. Well, let's see what answers you have. Then we go over to Lawyer Charles Osma to get the correct one. Nana Jemfi says that he should seek permission from his employers before carrying over all his holidays to the following year. Nana Jemfi is saying so. So it's number one, he says. Ernest Ofori thinks it's number one as well. Thank you, Ernest. The next one is Nana Usu. Nana Usu also thinks it's number one. He should seek permission from his employers before carrying over all his holidays to the following year. Alex Opoku thinks that it's number two. Kofi must take at least 4 weeks of his holidays, and with the employer's permission, he can carry over 1.6. Mark Best also thinks it's number two. Thank you, Mark, for that. Let's see what Kojutufu also says. He says it's number one. He should seek permission before he can carry all to the following year. Babalas thinks it's number one, agreeing with the previous person. Let's see who else we have. Tilly Duma also thinks it's number one. Kofi should seek permission from his employer before carrying over all his holidays to the following year. Thank you, Tilly, for that. Who else has anything? Emmanuel Awuku, Kofi cannot carry over of the holidays at all. I guess that's what you want to mean. Emmanuel Awuku, thank you. Kwesi GH says it's number two. Kofi must take at least 4 weeks of his holidays. With his employer's permission, he can carry over 1.6 weeks to the following year. I think if there's one, I'll take one more, and then I will go over to lawyer to find out what would be the best answer to give Kofi in the context of the law. Solomon Wako thinks it's number three. Kofi cannot carry over any of the holidays. Lawyer, did
Thank
we
you
get
very
it
much.
correct?
Thank you very much. So we looked at the Working Time Regulations 1998 with respect to leave holidays for
Mhm.
workers. We were clear that the rules say or the regulations say that if you are an employee or a worker, you need 5.6 weeks of annual holidays. However, you can carry 1.6 of that, and you must use 4 weeks in the current year. So if you're ever thinking of carrying over or forward any of the time or leave days you have, you can only do so for 1.6. That is the rule. Kofi is saying that he wants to have 2.5 months, which is 2 months and 2 weeks in the next year. So he wants to carry all his 5.6 weeks holiday to the next year. What will you advise him? The advice is that if he does, he will lose the 4 weeks. For 4 weeks, he has to take it. If he doesn't take it, he will lose it, but that cannot be carried forward. However, the 1.6 weeks, he can only have it carried forward if he discusses with the employer and the employer agrees. Number one, if he wants to carry over all, can he do so? No, he can't. He can only do so for 1.6 based on agreement with the employer in writing. Two, Kofi must do 4 weeks now and carry over 1.6 weeks with the employer's agreement in writing. Yes, that is what the law says. Somebody says that Kofi cannot do that. No, Kofi can do that, but only for 1.6 of the weeks he has. So two.
Must take at least 4 weeks of his holidays and, with his employer's permission, carry over 1.6 weeks. So, number two is the correct answer. So, those of you who said number one, number three, unfortunately, that is not what the Working Time Regulations of 1998 says. The basic principle of use it or lose it remains in general terms. Remember, an employee should take the annual leave during the annual leave year in which it was accrued. If they choose to take the leave entitlement, this will be lost at the end of the financial year or the annual leave year. No payment for accrued, but no, on taking leave will be made in those circumstances. Amendments to that were made in January 2024, and these regulations provide for holidays to be carried forward into the next leave year in certain circumstances. And from the WTR 1998 and from 2009, people are allowed, with the permission of a written permission, so to speak, of the employers, carry over part of that. And that's what we discussed in that. Lawyer, before we go, there's a question here from one of our viewers who is talking about ETA UK. He's asking whether it's coming to force.
Yes, the travel authorization is in force. I know those coming from the EU have to get ETA before they come to the UK. And what I also see is that those coming from the EU with ETA or the ETA to the UK are given 6 months time or 6 months leave in the UK. Instead of the standard 3 months or 90 days, they get 6 months once they enter with the ETA.
Okay. All right. I believe that would, at a point in time, become one very full topic. We will be discussing these changes, and of course, some of these strengthening of immigration regulations would come into force. With that, I want to say that we've come to the end of the discussion for today, how to successfully make a spousal application whilst in the UK. But let's get a summary from Lawyer Asma.
Hello, viewers and listeners. Thank you for staying through and through with us. At this point, we are clear that if you are in the UK, you can apply to remain with your qualifying sponsor or partner. We've also understood that there are two sets of people, those who have visa and switching to the partner visa, or those who have not have no visas and applying to remain with the partner. Those who have visas can only evidence the criteria for relationship, criteria for income or finance, criteria for accommodation, criteria for English language. Because they have a visa, there's no reason why, if they meet the requirements, the caseworker will refuse them. And for those people, they have very high chance of success. Those people who have overstayed may have limited chance of success because the case law position, the case of BAT versus the Secretary of State, 2025 says that in doing so, you can go back to your country and have your relationship with your sponsor there. You don't have to be in the UK. The only way you can succeed is if you can prove that refusal can bring hardship or untold consequence for you and your partner. And this could be life threatening. And if that's the case, and it is well evidenced, then you are likely to succeed under exception rules under paragraph EX2B of the rules, and also the case of BAT and the Secretary of State 2025. Otherwise, remember that while those who have visas can easily switch and be successful, those who do not have visas may not be successful if there are no exceptional circumstances warranting that, or there's no child in the equation to make the decision to refuse unreasonable or disproportionate, that it's not in the paramount interest of the child. This is the conversation for today. Thank you.
Thank you very much, Lasma. That has been the conversation for the day, and I believe that you have had a benefit from that. If you need further explanation, if you need further discussion on that, please go to BWF Solicitors on their website. Leave them a message by sending an email, or you go to the social media handles at BWF Solicitors and you leave them a comment. Or you can send a text to 07399208 You can call BWF Solicitors on 0208 493 7340. In Ghana, 055 Emergency situation 077 127 61884. We have had a very lively discussion. You have contributed. Thank you very much. I appreciate you so much. And I would want to invite you to join us again, same time next week. But before then, let's say thank you to Lawyer Charles Asma for his time, share of knowledge, and to BWF Solicitors from the senior partner to the very last person, including me. I want to say thank you very much for being part of this production. To my production team, Shilanka Padmodudu, and my producer, Professor Ade, we say thank you to you all. And to you out there, thanks for your time. My name is Oreku Frimpon. Have a good evening. I'll be back again, same time next week.